Biden declares Equal Rights Amendment as law, a landmark moment or a symbolic gesture. On Friday, US President Joe Biden declared the Equal Right Amendment as the law of the land, a bold proclamation aimed at addressing gender equality. This announcement comes mere days before the vacates of Oval Office, passing the reins to President elect Donald Trump on Monday. Biden's statement has reignited discussions about the era an amendment initially proposed a century ago, raising questions about its practical implication in modern America. The era states unequivocally, equality of rights under the law shall not be denied or abridged by the United States or by any state or account of sex. Advocates argue that enshrining this principle into the Constitution would provide stronger legal protection against gender discrimination, promote equal pay, and underscore the nation's commitment to gender equality. However, critics maintain that the time for its ratification has long expired, rendering its relevance moot in today's legal framework. Originally introduced in 1923, the era was passed by Congress nearly 50 years later in 1972. US law requires that constitutional amendment that ratified by three-fourths of state legislatures. While Virginia became the 38th state to approve the era in 2020, opponents argued that the ratification deadline set by Congress in the 1970s has already lapsed. This position was upheld by the national activist who declared the era ineligible for certification due to established legal precedents. Efforts to revive ERA faced a significant setback in 2023 when the US Senate failed to garner the required 60 votes to bypass a filibuster. Falling short with a 51 to 47 majority, the opposition's argument largely hinges on procedural technicalities and claims that contemporary law sufficiently address gender discrimination. Meanwhile, proponents contend that constitutional recognition would fortify gender equality protections and signal a broader societal commitment to fairness. President Biden's declare of the era as the law of the land marks a poignant moment in the long and contentious history of the fight for gender equality in America. While the announcement may lack immediate legal authority, it reignites an essential dialogue on equality, justice, and enduring legacy of constitutional principle. Whether this marks a turning point or merely a symbolic gesture will depend on the collective efforts of lawmakers, activists, and the judiciary in the years to come.